we certainly preserve our rights as it relates to their absence, but we request that there be an agreement amongst the parties in this court that by their failure to attend, they have waived their rights as it relates to this contempt hearing today after the lawful subpoena was served. The second issue we'd like to bring to the court's attention is there were several filings that we actually received this morning while we were already here in court. One was from an individual citizen, and one was from a new attorney that has appeared as a counsel of record for two of the individual defendants, Ms. Ivory and Ms. Barrett. We have not had an opportunity to review that in advance of the hearing. 9:40-ish, but Your Honor, we will obviously happily address anything we can at this time, but we do not believe that either of those filings change the underlying merits of our argument or our motion that is before today. Your Honor, we're here seeking extraordinary relief under extraordinary circumstances brought upon the defendants by the defendant's own doing. Not once, not twice, not 3 times. The BOC met and refused to comply with this court's writ. Most egregious, on the last Wednesday hearing of the Board of Commissioners, the defendants refused to comply with the writ after this court had issued an order denying their motion to stay and states that if they do not comply with the writ, this court will take back up the plaintiff's motion to hold them. Contempt is the only legal mechanism left either in plaintiff or this court's disposal. Defendants have made clear on numerous occasions that they have no intention with complying with this court's order. For instance, at the last hearing, last Wednesday, Commissioner Barrett said, no judge can compel any elected official to vote in a certain way because we are hired by our constituents and only constituents can remove us from office. No court, no lawmaker, no political party can compel me to act any particular way. Commissioner Barrett's colleague, Commissioner Ivory, who is an attorney in the state of Georgia, stated, I respect the authority of the court, but I also, like has been mentioned, have a duty to the people that I represent. The act of voting is discretionary. Any vote, the ones we take here, or the ones that you cast when you vote in the election, discretionary. No one can tell you what or how you should vote. These two commissioners didn't stop there. Each got on social media to proclaim their independence from any court's authority. Your Honor, we have 2 videos that we would like to share.
We have a couple really important agenda items that I want to make you aware of. First of all, we will be having an emergency add-on to our agenda to respond to the judge's order that we as a board appoint the election deniers Jason Frazier and Julie Adams. Unfortunately, the court has ruled against us, which I think is the wrong ruling. We tried to get a stay from the Court of Appeals, that was denied, and so we will likely have to take this up today. And our elections are under attack in this country. We're seeing it with, obviously, in Texas. We're seeing it all over the country in different ways, and now they're talking about taking away mail-in ballots and electronic voting. And this is just another arena in which they are trying to chip away at free and fair elections and our right to vote and our right to have a democracy. And so, despite the judge's orders, I will never support putting 2 election deniers on our voter registration and elections. Not with my vote. I have free will, and I will not do it ever. I'm in this job to defend our democracy. And I've said over and over again that I feel like these county commission seats are the last defense. And so I will stand tall and take whatever consequences come my way, whether it's fines or jail, or whatever it is, because this is that important. The second item I wanted you to know about is
didn't even include any of the expenses of the consent decree. The right to vote is the cornerstone of our democracy, and this is where we left on the last vote today. So much happened today. I'm built for this. And those who oversee elections must be fully independent and accountable. My vote today, not to appoint the 2 Republican nominees to the Board of Elections, Registration and Elections, is my standing on my principles, whether the military or about MAGA Republicans. I'm gonna do what is right, and nobody can force me to vote yes on something that I have the discretion to use my research, my facts, my intelligence to make a decision for myself. It's dangerous to start opening the door to judges telling elected officials how they should vote. And I'll stand on that every day. So please go to FGTV and watch these meetings. You need to know what is going on. And of course, reach out to me, moivory.com. You can talk.
Your Honor, Commissioner Ivory is an attorney in the state of Georgia. And I will note, Commissioner Ivory and Commissioner Barrett have not changed their position. They were in the front of this courthouse holding an interview, to reiterate similar comments. Commissioner, those aren't the only 2 defendants who refused to acknowledge the rule of law. Commissioner Harrington, who was not at the hearing because he was apparently having surgery and better, took the time to post on Instagram after the vote, stating that he disagreed with the court's decision. Interestingly, we've now learned that not only does Commissioner Harrington post on Instagram, he has separately sent out text messages as recently as last night to constituents in Florida, asking for them to vote for him, not vote for him, but to provide money towards his campaign on the basis that he will not abide by this court's order. He went public in an article that was posted on Yahoo last night and stated that he is one of the 3 commissioners who will not back down and will not vote for this. And as bad or arguably worse, Commissioner Pitts and Abdul Rahman were present for the hearing last Wednesday, but they skipped the vote. Their colleagues, Commissioner Barrett and Commissioner Ivory, actually chastised them on the record for being scared to vote and face the consequences like Commissioner Barrett and Ivory were willing to do. But as Commissioner Ellis said at the hearing, it really doesn't matter, and it wouldn't matter whether they were there for the vote on the record or not. It had been 5-2 along party lines all along as to whether the Board of Commissioners would follow this court's order. By not obeying promptly and completely, as the Georgia Supreme Court spelled out in Frazier, these 5 commissioners are defeating the object of the writ, defying the authority of the judiciary, and discrediting the power of the judge. Put simply, taking them at their own words, these 5 commissioners would rather pander to their constituents than follow this court or any court's order. That cannot stand. Our legal system would fold under such willful disobedience. The 5 commissioners' acts have also cost the planet too. The Fulton County Republican Party has spent excessive amount of time and money and resources on trying to fight this issue. A special election was held just yesterday in Georgia, and presumably the certification of that will occur next week. The plaintiff will not have its 2 nominees there to certify that election. In addition, there's another election that is set to occur in November. If the defendants are not coerced by this court to abide by the writ, it is incredibly unlikely that we will have any ruling from an appellate court or placement of the two nominees on the Board of Elections in time for that election. And as we've already discussed, registrations are already ongoing for these elections. Now, late yesterday evening, the 5 commissioners went on the record and filed their response to our motion, which was filed last Thursday morning. The crux of that response was that it would be unfair and unconscionable to penalize the 5 commissioners for not abiding by this court's order and awarding civil or criminal fines or even attorney's fees. Now, plaintiff obviously disagrees, because that is the only option that this court has left. If the requested relief is not granted and defendants continue to file the writ, the purpose of the lawsuit will have been defeated, as the Georgia Supreme Court has said, by defendants' bad faith delay. Taking a closer look at their motion, what defendants seem to be attempting to do is to relitigate the motion to stay and our complaint seeking a petition for a writ. They tried to argue that not only would it be unfair, that if they were to appoint the 2 nominees, their appeal would be moot. Like it or not, this court, the Court of Appeals, and the Supreme Court of Georgia each had an opportunity to review the respective motions to stay that they filed, and for various reasons, the requested relief was denied by this court, by the Court of Appeals, and the Georgia Supreme Court refused to take it up. Defendants are not entitled to make this another hearing on the merits as it relates to the underlying relief that this court has already ordered. They should not, and they are not entitled to a third bite at the apple. But even so, and even if this court was willing to consider their arguments, defendants are simply plain wrong that they cannot appeal. At the outset, the defendants had an opportunity to appeal immediately after this court issued its order on August 4th. They did not do so. They waited over 10 days to file a notice of appeal. And more importantly, when they noticed that appeal, they did nothing to seek expeditious relief. It has been over 23 days since this court issued its initial writ, and nothing has taken place in the Court of Appeals because they failed to seek timely and expeditious ruling. It's all part of their plan to delay. And in the current standing, it is unlikely that the Court of Appeals, based upon how they filed a notice of appeal, would make any decision until 2026. Matter of fact, I believe that is what has already been scheduled in the current standing. Second, and maybe more importantly, they're wrong as it relates to mootness. If the 2 nominees were appointed at the hearing in compliance with the court's order, it would not render the appeal moot. Defendants totally ignored the doctrine of capable of repetition, yet evading review, which is widely acknowledged under Georgia law, under federal law, and is quite common in instances like this. In fact, both the Caldwell versus Bateman 252, Georgia 144, and Poitras versus Moses 250, Georgia 452, make clear that Georgia recognizes certain issues capable of repetition and therefore require review, even when the underlying relief sought has been acquired. In Caldwell, the court said, construction of this act and a resolution of the constitutional issues raised will give guidance in any future challenges by candidates subject to the authority of this commission. Alternatively, in addition to guidance, in Poitras, the court held that the case was capable of review because the time period between the determination of qualifications of the candidate and the day of election is brief, and because the opportunity for review is diminished. Both instances exist here. The appointments of 2 nominees from each of the political parties has been on the consent agenda for numerous terms in the Fulton, before the Fulton County Board of Commissioners. It was only in 2023 that the Board of Commissioners first took it up as a vote and decided to deny Jason Frazier. A lawsuit followed. The same issue occurred in May 2025. This lawsuit followed. Based on the commissioner's own statements, it's likely we will have this issue arise before another court again. In addition, the time period between nominations, appointments, and the beginning of the term for the Board of Elections is short. As this court knows, and is seen here, there's really only roughly a month between the time in which the appointments are set to occur and the time in which the Board of Elections begins its term. And as we've seen here, in this instance, even when you attempt to file a lawsuit, judges can recuse themselves. There can be reasons for delay. It is very difficult to obtain both a Superior Court ruling and any appellate ruling within 30 days. This issue has already been proven capable of repetition and capable of evading review in this instance, and it will continue in the future. And for those reasons, we do not believe that it will be held moot. Nevertheless, plaintiff is very dubious that the defendant's argument of mootness is anything more than pretext for their underlying motives. When Commissioner Ivory states on Instagram that it's dangerous to start opening the door to judges telling conviction elected officials how they can vote, or Commissioner Barrett states on Instagram that despite the judge's orders, I will never support putting election deniers on our board of registrations and elections. I have free will and I will never do it ever. They are refusing to do so to protect their legal rights. They're emphatically stating that they will never comply with any court order that they do not want. That cannot be the standard. Again, this is a lawyer-driven, pretextual, post hoc argument to cover their underlying motives, and it should be dismissed. Finally, the plaintiff assaults civil contempt in its prior motion to coerce the defendants to comply with the writ after they failed to abide by this court's order at the August 6th hearing. We saw that after they failed to abide at the first hearing. That it did not abide by the court's order. So now we have come back to the court and we've asked for both civil and criminal contempt. We believe would be appropriate in these egregious and extraordinary circumstances. Civil contempt is a mechanism for the court to tailor monetary sanctions or imprisonment to coerce defendants to act. The sanctions can have a remedy through which defendants can state that they are willing to comply after each day goes by. Alternatively, criminal contempt is a mechanism to punish the 5 commissioners for their failure to abide by the court's past orders. The sanction would simply retroactively punish them for their disobedience with those orders. We believe stringent sanctions are necessary as laid out in our motion, and as Commissioners Barrett, Arrington, and Ivory say that they're willing to accept. But we leave such decisions in this court's able hands as to what it believes is appropriate. Additionally, we believe the defendant's actions have been in bad faith. They were strongly litigious and cause unnecessary trouble and expense. So therefore, we are seeking our attorney's fees as it relates to the past two motions and everything that has occurred surrounding them on motions to contempt. Such attorney's fees, if awarded, would not be paid back into the county's pockets as a fine for contempt would be. Democracy is dependent upon public officials following the law. That applies to all persons, no matter one's title, no matter one's party. And we ask this court to take our motion seriously today and to use the only mechanisms left and available to it to ensure that these 5 defendants are now above the law. Thank you.
This is Bill Quinn. You're watching live stream reporting from Fulton County Courthouse regarding the hearing to consider contempt against the Fulton County Commissioners for failure to place Jason Frazier and Julie Adams in their positions on the election board. Now back to the court.
All of it, 7 recognize the authority of this court, not to find the court's order out of anger or even because they disagree with it. They are, in fact, seeking to protect their appellate rights. Disagree with counsel. We had many discussions about this. I would just want to add just parenthetically here, as you invited us to negotiate and discuss this matter, and we did so. Plaintiff's counsel and I had many discussions over the last month, productive discussions. I can't get into the specifics only because we're already but we made a lot of effort trying to resolve this dispute here, and we disagree about the law. There are very few facts that we disagree about, but for sure, the people that I represent, and I represent all the commissioners actually, not just the 5 and the county, I'm not to find this court out of disrespect to the court in any way. I can personally assure the court that they are, in fact, worried, as our counsel, with moving this issue. And there are cases, including cases we've supplied in the court in our brief, that we say once the injunction, once the relief is obtained, it is moved, including appointments. The Rogers case, it's in our most recent brief, had the exact same issue in different context, but the same issue where someone challenged the method of appointing members to the medical board, one of the public boards. And the court agreed and said it's moved because they've already been appointed. And we're not going to remove them from office, someone who's been appointed. So we are very concerned about this. And in my conversations with plaintiff's counsel, in fact, you believe that the 2 of us can't wait to move this. The appellate court will have to decide whether the issue is moved. And if in fact an appointment is made, I'm going to get further the issue of appointment versus voting. If in fact an appointment is made and then goes to the board, they can't be removed. There's no method by which they can be removed, even if it's capable of repetition. That they review all that happened would be the 2 years from now. And new ruling by the court is still the impact, the method by which the selection process goes. It would not change the fact that 2 people have been appointed, that the commissioners, the sub-commissioners, would be should not vote. I want to distinguish, and I don't mean to get hyper-sound here, but the court has ordered the county to appoint the 2 members. Individual board of commissioners do not have a appointing power. The people who vote no can't appoint anybody. They don't have the ability to appoint. Only the board of commissioners to a majority vote can accomplish the appointment. There's nothing for the commissioners, the individual commissioners can do. In fact, in virtually any of their activities other than voting. That is their sole method of accomplishing the business of their legislative body. They have to vote. There's nothing they can do to appoint. Maybe it's a problem in the language of the legislation. They have no appointment. Even if 5 of them got together and said, let's appoint someone, they can't appoint anybody. All they can do is vote. their view, whether right or wrong, but their view was that they obeyed the writ by voting. That's the only thing they had the power to do, which was to vote. And I questioned one of them, actually I talked to one of the members, and I said, have you ever been told before you voted on hundreds of issues they vote on a monthly basis, monthly basis, hundreds of issues. Have you ever been told if you vote no, you're going to be a criminal contempt? That you will commit an offense by voting no? They said, of course not. The whole point of voting is for us to make this exercise our discretion in the way we think is required. And so we've never been told by anybody, by any lawyer or anybody, we have to vote a certain way, that we are required to vote. We understand that counting is required to a point. We don't contest that. It may be that this court can craft a maybe the Republican Party wouldn't contest the authority of the court to issue a writ that says the county must do this. You can't compel individual legislators, individual members of the board, how to vote on any given issue, even if it seems unquestionably the appropriate thing. They're allowed to have a dissent. That's what happens on the Board of Education elections. They vote, they have contested votes on a number of issues at the Board of Registration. With regard to the August 13th hearing, Plaintiff's counsel, neither Mr. Gates nor Mr. Harrington were present to vote. Who did vote was known to be absent. I don't know how the plaintiff can seriously contend that when someone is in the airport flying to Africa, when Mr. Harrington just had surgery, is a willful contempt when they don't vote in an election. So I would argue the court, and I know I don't think I had a chance to review the plea filed by two of the individual commissioners that are individual capacity, that they certainly don't have a power. None of the individual commissioners on an individual basis have the ability to appoint anybody. And it's only as a body, only as the Board of Commissioners, as an institution, can appoint anybody through vote. So I would suggest to the court, if relief is appropriate at this point, if the court would be able to stay at proceedings, appeal, and the court was going to stay at the appropriate relief to the board itself in their official capacity, and not the individual members who have no authority or ability to even merge themselves into the task. Only the institution, only the county itself. There have been previous times when the board has voted on the board registration, where someone dissented. Nobody would have contended when it was 6-1 to make the appointment. That the dissenting vote was the contempt of court, or the dissenting voter had done. So it requires a majority vote to accomplish the appointment. Are we going to say that every time that there's a vote for an appointment like this, anybody who votes against the nomination is in defiance of the law, has violated the law? That in essence is what the plaintiffs are saying here. You must unanimously vote. You must unanimously vote in favor of the person appointed by the Democratic or the Republican Party. You may not dissent. You may not vote against the nominee, regardless of your reason. You must. The law is awkward in saying that the fact that Board of Commissioners must appoint. It doesn't say they have to vote. Every single one of them must unanimously vote in favor of whoever's nominated by the political party. It is in all respect, I think it is a defect in the law. The law, like they do in other counties, in some counties, we gave you last session all the different county laws. Some of the counties simply say the political party shall appoint. and they leave the board of commissioners out of it altogether. There's one county that makes the chief judge of the Superior Court judge the ultimate authority who gets it. But here they say the board of commissioners has to appoint without recognizing that the board of commissioners has no authority to appoint. They can only vote. That's what the commissioners do. They vote. Again, with regard to the August 13th election, there were only 4 people present. Now, imagine if it was 5-2 or 4-3. 3 people dissented and said, we don't want the person nominated, but 4 did. And so the appointment occurred. Would you say that the 3 people who dissented and said we don't want these people appointed, that they committed a crime, that they were in contempt of court, even if the appointment ended up going through? That's their theory. You cannot vote. It's the plaintiff's theory. You may not vote. No. You are nothing but a rubber stamp. You have no authority. You didn't even need to have an election. You didn't even need to vote. You're not allowed to vote. You're not allowed to vote your conscience. You're not allowed to dissent. So the one thing you can do, put it on the agenda and vote yes. And anybody who dissented, anybody who said I vote no, under their theory, should be held in criminal contempt. In theory, even if the appointment occurred, they would say that, because they violated their rule, their obligation to be a rubber stamp. I think that is not what the law permits. These are elected officials, they're public officials, they donate an enormous amount of time to this county. They do it very little remuneration. They're constantly at the beck and call of county attorney's office, all the duties that they have to do. They're dedicated public servants, just like you are. And they are not in defiance of this court. They are not disrespectful of the political process. They're not disrespectful. And I know that from having spoken. They are not disrespectful of the judiciary. They disagree with you, Judge. So the lawyers in the case, I bet it's happened before. They want to appeal. They want to avoid what happened 2 years ago and then again this year. They want to avoid that from happening. They want the Court of Appeals to say, Mr. Samuel, you were right. The writ was improperly granted by the good Judge Emerson. He was wrong. He made a mistake. I think he made a lot of mistakes. We want to ask the Court of Appeals, is it appropriate for a private party like the Republican Party or the Democratic Party to have the appointment process? We've cited, it's in the footnote in our brief we filed last night. There are cases in the Georgia Supreme Court that said private parties may not. They're not allowed to make appointments. It violates the Georgia Constitution. It's the case called delay, ironically enough, and another case called Rogers, both of which say a private party may not appoint people to a public board. We want to raise that issue with the Court of Appeals. If this court says you may not do anything other than appoint these 2 members, we believe it will be moved. Maybe we will succeed in changing the law 2 years from now, but we will not be able to undo. And I don't think the Republican Party disagrees with me on this. You will not be able to undo compliance with the writ because then now they've been appointed. And the Court of Appeals, the Supreme Court in the Rogers case said, even if the appointment was improper, we can't remove someone. That's the Rogers case cited in our brief. So, yes, it's true that we can probably, somehow get the court to rule, but it won't apply in this case. It won't give any relief to the Fulton County in this case. I understand for lack of a better description, the high octane argument of plaintiff's counsel. It's a little overwrought, I think. I absolutely disagree that we are guilty of delay. I can't even understand the argument that because it took me 4 or 5 days to craft a brief to get a say and file it, that I'm guilty of delay, that somehow it was an unconscionable delay. You know, when we filed a notice of appeal, you know, a week after the decision was reached. And delay didn't harm anybody. They have 2 Republican members on the board to this day. We haven't sought to remove them. We haven't said you need to vacate your office. They're there today. They haven't been harmed by the 1 week delay in filing the notice of appeal. And we weren't advantaged by taking the delay. So this whole argument that we are guilty of this unconscionable delay is just, with all due respect to my new friends, it's just unconscionable, it's just wrong. We are, and we've talked about expediting the appeal. We've discussed an agreement where we could, and again, I don't want to get into violating Rule 408 here, so you're clear of that, but we will commit to expediting the appeal. We will waive oral argument. We will expedite expeditiously file pleadings in the Court of Appeals. We think it's important for the Court of Appeals to decide this case. We think it's important for the Court of Appeals. We thought it was the Supreme Court. They didn't rule on anything other than that they claimed not to. They decided they didn't have jurisdiction.
They don't claim right.
They're wearing the robes and they decided. I claim, I already, they decided. So the Supreme Court hasn't ruled on anything. It's unfair to say 3 bites of the apple already. The Court of Appeals denied our stay, a matter of hours after receiving it. We think they will reconsider, they certainly reconsider whether a contempt order is appropriate in this case because of our rights to supersede. We can't help reading in the paper these days, the defiance of the judiciary in all places at all times. And there's nobody more concerned about that than the lawyers in this court, including the lawyer on the board. We're all concerned about respect for the judiciary. And we are not, despite the plaintiff's kind of overbroad argument here, we're not in defiance of the law. We are trying to protect our rights as judicial. And that is as much a part of our judicial system, as much as a part of the requirement of the due process. If you respect the appellate process, if you recognize that maybe once or twice in your lifetime you've made a mistake that needs to be, the Court of Appeals needs to weigh in on this. And you don't have to find these people or criminals or criminal contempt in order to protect the integrity of this court, to protect the integrity of the Court of Appeals. If the Court of Appeals, I can absolutely guarantee you, I would bet my bar card. Well, I don't know that many more years in which I'm going to be using it. I would bet my bar card that if the Court of Appeals says your clients are wrong and the writ is properly granted, you won't hear from any of us again. It'll just be the way it is. They may go to the legislature. They may try to change the law. They may ask the law, the local law be changed to clarify why are we voting, why are we even sending it to the Board of Commissioners. If you want the Republican Party to appoint to, if you want the Democratic Party to appoint to, and nothing else, leave us out of it. There's no reason to have the Board of Commissioners in this process. So I would ask the court to be, I recognize you're not going to just sit there and do nothing. I recognize that. And I've told the clients that. I've told them. He's not going to say, I'm so sorry for the inconvenience. Go back. We know that's not going to happen. We ask you to be respectful of the other branch of government. They are not evil people, despite the way you think the plaintiffs are describing them. They're not volunteers, but they have very little reward. Serve this county, vote their conscience. I would never tell anybody, don't vote your conscience. some members didn't vote at all. I don't think that was in defiance of the court. You know, someone's on an airplane going to Africa, and they're saying, well, hold it, criminal. I think I said it when I was saying, voting is incredibly important. Whether you're a legislator, I can't make a speak on any congressman. Any congressman is because they voted no or yes. If you feel compelled to have some kind of civil coercive contempt order, and we urge you to do it against the county, not against the individuals. These people don't deserve that. They don't deserve to be criminally decided. One of them has bar cards. They don't deserve it. After all the work they put in to try to be good citizens and good public officials.
Real quick question, Mr. Sanger.
Absolutely.
This all revolves around the local legislation, Fulton County, unique to Fulton County. That's right, look at all the laws across the state, but as far as I know, this is unique to this county. And of course, the text of the legislation says that the commission shall appoint the people who are nominated by the respective party executive officers. Interesting, but that's what the General Assembly, that sits a couple of blocks from us, adopted. That's the law.
Yes.
That is applicable here. It's not what the court wants, but I don't get to vote on or decide on which laws I like either. So, I didn't see anywhere in that legislation that the commission was given veto power over the nominations. Is it in there? Did I miss it?
Certainly
Okay, so then that's my concern. They don't have veto power because of the law that applies to this selection process, and that's what they're essentially doing.
I respect do everything I do with respect. But I'm going to disagree. You're right, they don't have veto, but they are told you have to vote. And it is incomprehensible to tell someone to vote. But it's just a rubber stamp. There's nothing in that law that says you are a rubber stamp, or as William B. Conley lawyer famously said, Representative Oliver North, I'm not a potted plant. These people are not potted plants. When they were told to vote, they were told, and you could only vote one way. They weren't told that. They were told that by counsel. They were told that in the executive sections, the agendas. They were told you need to go out there and publicly vote. And I understand, of course, I'm not saying you're flat wrong. I understand that. It would seem that what the law should have said was, the county should appoint, or some way to avoid putting individual members in the position where they have to vote a certain way. And if I'm wrong, Judge, the Court of Appeals will tell them they're wrong. And just the way the structure of the statute works and the way the structure of the Fulton County government is, you have to vote yes. That's what you have to do. You have no choice in that. And if they say that, they will do it. They will do that. But so far, we don't have. We have your granting of the writ. And the writ says that you have to tell them to act. It doesn't say that you put this in the order. In the denial of stay. That's in the original brief we did way back, all the month ago. You can't tell them which way to vote. You don't have that authority in it. You can just tell them they have to vote. Of course, they characterize it as you have to tell them they have to appoint. They can't appoint.
decide we can't appoint anybody. She doesn't have that power. Mayor can't appoint anybody. Nobody's given them a document that says, here, sign here and appoint. All they can do is vote. And that is the antithesis of that man. Where the law is absolutely clear, you can't tell them how to exercise their discretion. You can just tell them you must act. You put that in the notwithstanding, you quoted that way. And it's right.
Quickly, absolutely. Candidate in the here, so.
One second.
Co-counsel, counsel for the county pointed out that the law says that you must appoint from the nominations, plural, from the specific political party. And thus it envisions there's more than one nomination that can be made. And in fact, that's what happened 2 years ago, was a different nomination was made and approved, and he's on the board as of today, because of this, he's coming off the board. So, you know, the plaintiffs can still have the appointment. And what some of the counties do, in fact, I pointed this out to you the last time, some of the counties require that the political parties nominate more than one person, so that the appointing authority has a choice to make. That's not, it's unclear when the Fulton County Divisions Act, by saying nominations plural, that from the nominations of, it's not just Republicans, it's Democrats too. Because it envisions multiple nominations, that would allow the board of commissioners then to make a choice. Which is what I vote envisions. Any other questions?
No,
You got the agendas.
I do, and I haven't had a chance, you filed something late last night that I'll read over, your, they probably read, file.
It's broken. I don't think you want to miss it, but
Well, as I said, y'all know, in my practices,
I know.
we write long orders after I have had time to adequately read over everything in the certification.
And if there's any way I can commit to expeditious review in order to satisfy you, and I'm telling the players council that, you can agree on that, we can just let the court of appeals know you got 1 week to decide. We'll tell.
I'm sure they'll, that's just be on that.
Mr. Shannon says so.
How smooth as the appellate courts choose.
Thank you for caring for me and,
John, when Mr. Samuel and I were talking over the weekend, I wish I would have been able to come on with this second appellate courts move as the appellate courts choose, but that was one of the rebuttals that, and I would certainly say without going into Rule 408, but because it brought this up, the proposal made to us was not simply that they would move to proceed expeditiously. This is the first time that has been put on the table or has been offered without other conditions associated with it. Nonetheless, I don't think it's appropriate for that to be before this court, and separately, the court, allow all of that conversation to be ignored as it's a membership of the product to begin with. Mr. Samuel states that they have no choice but to vote, and they have to vote their conscience. This court actually said in this order, the court knows the rule in this type of case, that the court can only compel the public body to act while it cannot dictate the decision that must be made. That said, this is a situation in which the only authority of the County Commission is to appoint the nominees submitted by the executive officer of the political party. the defendants leave out the second sentence. They also ignore that the statute in question sets out 3 conditions and criteria in the law that they are in place to ensure were met before appointing them to the board. Their discretion is to ensure that the candidates nominated by the parties are in line with the criteria laid out by the General Assembly. Mr. Samuel also quipped that they haven't had 3 bites of the apple. They have, Your Honor. They responded to our petition, and we had a hearing in which we held out. They filed a motion for reconsideration and a motion to stay, and we had a hearing on that. And now we're here again today where they are retreading and making the same arguments they previously made. We aren't here to relitigate what this court has previously ordered. There's not a motion for reconsideration on the table. This is for the court to consider what sort of relief, contempt relief and attorney's fees are appropriate after they knew and were conscious of what might happen if they failed to abide by the court's order. This idea that individuals cannot be compelled is nonsensical. There is no authority that they have ever cited for that in any of their briefing. And I would point the court back to some of the cases that we cited in our early briefing. Town of Adel versus Littlefield, 149 Georgia 812, and Smith versus Lot 156 Georgia 590, in which the Georgia Supreme Court upheld prior issues of a writ compelling individuals, all public bodies, to take action. The idea that individuals cannot be compelled to take action would defeat the entire purpose of a party seeking a writ of mandamus. And they have no case law or authority whatsoever to support the proposition that Mr. Samuel raised with this court. We don't agree that the 2 nominees if appointed could not be removed. I would again point the court back to the provision within the statute that considered how you remove a member of the Board of Registrations and Elections. The General Assembly had already taken that consideration into account when they crafted this law. And there is a removal process if that is what they are seeking to do. While I understand that Mr. Samuel was attempting to make the point that there is political action that these county commissioners have to undertake in their roles, I think it's a little disingenuous to say that they didn't understand the consequences of their actions by not voting to appoint the nominees. That's contrary to the 3 of them who have gone out on social media and stated that they understand that actions have consequences. His question as to whether what you do with 1 of the members, 2 of the members, or 3 of the members, that is the defendants trying to make difficult questions out of simple requirements. They're simply trying to play games where it's not a difficult concept. Under the court's orders, it was very, very clear that where the nominees meet the 3 criteria under the statute, the Board of Commissioners must then appoint them. There is no discretion. This court has written approximately 12 pages of different orders, and the relief that was sought by the plaintiff in this action is spelled out specifically in its original petition, and this court ordered that that relief be carried out. The Rogers case that he referenced is actually a case that I brought before this court at our last hearing. The Rogers case, yes, while it says that the state of Georgia does not want as a public policy for private organizations to be able to appoint individuals in public bodies, the case goes on to say that the General Assembly or the legislature should set up a process such that nominations are made, the public bodies take those into consideration, and the General Assembly can put considerations or criteria that the party follows. And again, that's what happened here. This idea that that case is supportive of their arguments is nonsensical, and it frankly ignores the plain language of the case. There was also a statement by Mr. Samuel that there has been no harm to the actual plaintiff because they have had a representation. Your Honor, that is simply ignoring the affidavit that was submitted. As this court is aware, Board of Elections member Mr. Egan asked not to be nominated in the position because he had health and family issues. No different than Mr. Arrington, who said he can't be here today because of medical issues. Mr. Egan has served on the board reluctantly, even through these health issues, but has stated that he cannot continue to serve through the end of August, and I understand that he will not be there for the certification of the election that occurred yesterday. It's next week, and he plans to resign at the end of August. This idea that there is no harm also ignores the fact that Mr. Egan is not the nomination submitted by the Republican Party. In sum, Your Honor, I am not sure what advice was provided to the defendants by their counsel. I am not sure other than taking at their word in their statements on social media out to the public as to what their true intentions are. But this court issued an order. This court issued a second order. And the order of the writ, by their non-compliance, is being defeated. It is not for them to second guess this court. It is ironic to me that one of their chief complaints about one of the nominees, Ms. Julie Adams, was that she filed a case seeking in the previous board of election term as to whether or not she had to, as a duty, as a member of the board of elections, to certify the election. And when the court said that she did, she ultimately complied with that. Yet now, they want to be on the other side of that argument. And now they're challenging an order of the court, and they're saying that they don't have to comply. It's pretty rich. This is not something that we filed lightly. It's not something that any of us expected when we filed our initial petition, that after obtaining a writ from the court, we would have to come back before the court again and seek and argue a motion for reconsideration or stay. We certainly contemplated that was a possibility. We certainly contemplated that they might have filed a notice of appeal and saw an expeditious review of the situation. What we never contemplated was that something so egregious as this court would say, here's my writ, you must follow it. You're aware of the law that says that it has to be followed immediately. You refuse at the first hearing, despite knowledge of that law, to abide by the court's order.
Just raise that other case. Adams versus Fulton County, and I have that on West Florida here. Because I was not working here right now. But I did have access through my cellular device. So interestingly, that case related to the interpretation of the word shall which is what this case revolves around, albeit in a different concept. This is Court of Appeals. Cited one of the same cases that I looked at, internal vigilance. It's the short name of it, 2025 Georgia Court decision. And they said, quoted, the word shall is generally construed as the word command. The import of the language is mandatory. Based on foregoing Adams' contention, and Adams is what you're familiar.
She's one of the nominees, yes, sir.
That the trial court erred in saying she had a mandatory duty to certify the election results is without merit. And as I noted, that's one of the cases that I looked at in making my decision, is that the position of Fulton County in that case, which just came down in July, which makes this case all that great. All right.
Let me respond
I'll
to
go
that.
back into Smith.
Thank you.
Your Honor, and that's exactly right. We actually cited that, in our reply before the court ordered on its vote mandates. The difference, the distinguishment, and again, we think the case law is clear as the word shall. We're not here to relitigate that. What we are here for this court to consider and review is the difference in that case is that upon that order by the court, whether she liked it or not, she complied. And here, upon this court's order, whether the commissioners liked it or not, they're refusing to comply. They are, in a nutshell, attempting to seek someone, to keep someone off the board. They won't follow the law. Your Honor, this is, again, extraordinarily, this is not something we request lightly. We have laid out different types of contempt that are available before the court. We also believe that our attorney's fees are appropriate in this instance. And we leave it in your able hands. We believe that everything that the court has stated in its orders to date has been well reasoned. It has been based on the law. And we would ask you again to review the law and look to the law, not to the proposition without any authority or the general arguments that the defendants are putting before the court today. Thank you.
Thank you. And I'll let Mr. Samuel respond, and you'll get one more word. Samuel, yes, what do you want to add?
I think the real honor is that it was an appeal in that case. And, you know, despite the fact that Judge McBurney ruled against her, nobody said, and if you don't do what Judge McBurney says, you know, upstairs here, you're going to be held in contempt. She appealed. That's how they got to the Court of Appeals, and ultimately maybe the Supreme Court. But that's what we're asking for, is to have to say what is happening. And I would also point out, this happened with an elected official, you know, like she's an appointed official, and that's there's a difference between that and not having a constituency. And in our case, we are not saying that shall was voluntary. That's not. We put that in our original brief, and everybody agrees the word shall often means must. I recognize that. Sometimes it does, sometimes it doesn't. We cited cases to you where sometimes it doesn't. In Georgia case, it's a malleable word. We accept the fact. You're ruling that the word shall means shall appoint. The question is, before us today is, does shall mean you must vote? That's the problem here, isn't it? You were telling elected officials, not you must appoint, you shall vote, and you shall vote yes. If we're going to the Court of Appeals to tell us, just like they told Ms. Adams, and then she complied. That's all we're asking for, is the right to appeal. Is the right to appeal to have a meaningful appeal, and not have the plaintiffs, you know, then say, oh, by the way, this is all, they're on court, nothing to do with that. And even if they did do that, I think we both recognize that our agreement
it to make an issue just issue, or is not binding. Okay.
Anything else from the plaintiff?
One quick word.
Just limited to responding to this.
Yes, Your Honor. Keep it short. One word.
I hear that all the time, and there's lawyers standing and saying, just a couple of questions.
That's pretty easy. Your Honor, on the mootness argument, we have taken this position in open court. We have cited what we believe to be very good case law. There are numerous instances in which the Court of Appeals or the Georgia Supreme Court has found that these types of issues are not moot. It is again pretext. It is not the reason for the underlying motive that they are not following this court's order. And frankly, Your Honor, they had an opportunity to raise these arguments, the mootness of the motion state. We're not here to relitigate that today. We're here to decide what to do upon their failure to abide by your writ and their failure to acknowledge that this court warned them in their last order that it would be taking up contempt if they fail to abide. They made a conscious decision to willfully disobey this court's order, and they have their opportunity to appeal. We are not going to take a separate position on appeal after standing in front of this court today that it's somehow moot. It would have to be raised with sponte by the Court of Appeals. And again, the doctrine of capable of repetition, but escaping review will allow this case to proceed. They can have their day in court, but they need to follow this court's order, follow this court's writ, and appoint the two nominees as required by the Georgia General Assembly, as required by this court's order, in accordance with the law. Thank you.
Thank you. As I indicated, I don't think the rules and regulations have done on that practice 35 years or so now. And so I will make this, I'll give you please, but there's some mention perhaps of individuals that follow something, I don't know anymore.
It's on Odyssey this morning, I
And Your Honor, I've not read or reviewed those. If there is something that, we don't believe that it's necessary, we're not sure that they were following.
Well, I'll take a look at the document if the system is working. I know they did an update over the weekend, somehow it's pretty well recovered from. So, yes.
Thank you, Margaret. I'm Alexa Lawrence Party. I'm the lawyer who filed, so just wanted to let you know that I'm here.
All right, thank you. Thank you. And I'll have a decision for that. That'll be probably what was transmitted electronically. Thank you.
You've been watching reporting from within the Fulton County Courthouse of the hearing to be held regarding contempt, potentially, against the Fulton County Commission for failing to comply with the previous judge's order that they appoint two Republican nominees for the Fulton County Election Board, Jason Frazier and Julie Adams. Both of whom were duly nominated and submitted by the Republican Party of Fulton County, and yet the county commission has steadfastly refused to do their part and complete appointment of those people to the election board. In their arguments, the plaintiffs focused on the fact that the court had considered previous arguments and had said that the word "shall" in this case means that the county commission must complete its duty to appoint Julie Adams and Jason Frazier to the election board. They noted that the court had given ample warning in its last order that the commissioners would be potentially in contempt of court were they not to complete this. They also cited the fact that existing law, both in Fulton County and in the state of Georgia, supports that a court order must be complied with or can subject those in violation to contempt. Finally, they cited a number of different social media posts wherein various individuals on the Fulton County Commission actually posted the fact that they would not comply regardless of the penalties which might be imposed, and essentially denying the court's ability to compel their behavior. The defense cited a number of things, specifically calling out the fact that the commissioners have only one tool to use, which is their vote, and that they must be able to vote their conscience. They further suggested that a court may not compel individuals to act in a given way. The plaintiff came back and called that strongly into question. And most people will realize that court orders often, in many cases, not just this one, compel individual behavior and individual actions such that the individual can comply with the court's order. The court is now in recess, and the judge is now moving to consider the arguments from both parties. You'll recall that approximately a year ago, Julie Adams, who currently sits on the Fulton County Election Board, refused to sign certification for one of the elections, stating that certain information was not being made available to her or to the election board. In that case, it also ended up in court, and the court ordered that she sign the certification for the election, regardless of what information might be missing. So again, a previous case with regard to, again, the commission and the election board in Fulton County seems to confirm that, in fact, a court order may indeed compel behavior, compel action on the part of an individual, and that was cited within the hearing just ended as well. We will continue to watch this very carefully. The implications of a commission board being able to avoid appointing certain individuals is important, because this same dynamic exists across much of Georgia and could have a bearing on other election board appointments both this year and into the future. One of the things that the defense attorney cited was, well, we should have the ability to get to the appeals court, and we'll do it expeditiously, or we'll have the ability to go and have legislative change, but we can't do that today. The challenge, though, is that the previous court order compelled them to act, the commissioners to act, and they did not. And now they've been called, their attorney and the action has been called into the hearing held just today. So there'll be more to this. We are assured. The implications for this go well beyond Fulton County, across many counties in Georgia. And we'll be able to continue bringing this to you both from the Georgia Record, georgiarecord.com, and also CDM. We appreciate you being with us today, and we'll see you next time.